Hey y'all, so this is the recap and review for the Supreme Court confirmation hearing for Judge Katanji Brown Jackson. This is day one of, I think it's a 3-day process. Typically, day one is just opening statements. The nominee, which is Judge Katanji Brown Jackson, will give her opening remarks. And I think she had two witnesses, they call them, introduce her. So this is my recap and review. I'm watching it so that you guys will also go watch it and maybe, I don't know, get interested in it. Anyways, so it starts off with the chair of the Senate Judiciary, which is Dick Durbin. He's a Democrat. He gives his opening statements. I didn't take many notes on his opening statement. I think it was to the tune of, this is going to be an orderly hearing, a historic moment, because we do know that Katanji Brown Jackson is the first African-American female to have had a confirmation hearing held for her to be considered for the Supreme Court, to be considered for a justice seat. So Dick Durbin gives his opening remarks. Then the ranking member, Chuck Grassley, Republican from Iowa, gives his opening remarks. Same thing. He brings up, this is not going to turn into a spectacle. And he goes back to the Kavanaugh hearings, and we all know what happened with that. Maybe we'll do a deeper dive in a later podcast video about that. And then he goes into, originalism, and that'll come up several times during the opening remarks for day one, and I'll get into that a little bit later. He mentions that judges revise policy, and that makes it harder for the legislators to do their job. To paraphrase, he basically said that, the legislators, they come up with these laws, and then when it gets challenged in court, then the judges does a flip, and they say that the judges are legislating from the bench. And I don't know. I'll get into that. I think a few other members made the same remarks, so I will get into that. This is just going through my notes. So still keeping with Chuck Grassley, he also talks about how, I guess, they weren't able to get the reports that they requested from Katanji Brown Jackson's time on the Federal Sentencing Commission. He said the Sentencing Commission, they responded back and said that these decisions represent the commission as a whole and not solely Katanji Brown Jackson, which I think was 100% accurate. If it's a commission and they have to vote on whatever they're putting into the sentencing guidelines, the federal sentencing guidelines, then that doesn't represent her. That represents the commission as a whole. And to a certain extent, I don't think we need to create division within that about, oh, well, this person wanted this and this person advocated for this, and I would never advocate for that. So I think he was able to get some things, but not as much as he wanted. I didn't have that big of an issue with that. I thought that was fairly standard of the Sentencing Commission. They bring up, and this is going to come up some more times, they bring up Katanji Brown Jackson's, who she's represented over her course as an attorney. She was a public defender. She did have her own private practice for some time. It'll come up that she represented Gitmo detainees, and obviously as a public defender, she represented people who were accused of criminal actions. And as an attorney myself, I just would like to point out that we're taught in law school and in our ethics classes that when we represent clients, that's not necessarily us saying that we represent the views of our clients. You can represent the views of your clients as an attorney, but just because you represent someone, that doesn't mean that you agree necessarily with what they did. Particularly in Katanji Brown Jackson's situation, I'm gonna try not to make this a long review or recap and review, but I feel like I'm getting on my soapbox here. But hey, everybody has to start somewhere. I'm sure I'll get a little bit better at this. Anyways, Katanji Brown Jackson was a public defender for criminals. And we do know that in the United States judicial system, the criminal courts, everybody is entitled to representation. And so when we get into saying that, oh, if you represent this person, that means you agree to all of their actions, then we're leaving a group of people unrepresented in the courts, because nobody's going to want to say, well, if I represent them, I co-sign to this. No, you're not representing the views of your client. You're representing your client's legal rights under the law. You're representing their right to action. You're representing the fact that whatever this person is accused of, there still was steps that had to be followed to get them to this point. You're making sure that all the steps are followed. You're making sure that their rights weren't violated, and you're representing their best interests. A lot of people don't get that, but the fact of the matter is everybody deserves representation, or even is entitled to representation in the United States, criminal justice court system. And that's just a fact. And I always tell people, if that were your family member, maybe wrongfully accused, you would want them to have representation. If that were you, and even if you did whatever XYZ it is, you would still want to be represented. So I don't know why we keep bringing that up. Defendants are going to have representation, and no, the attorney doesn't necessarily. For example, a lot of people, Donald Trump had a hard time getting representation for his second impeachment trial because a lot of people didn't want to be associated with that. And I don't necessarily, agree with his actions in that particular moment, but he was very much deserving of representation. And his attorneys, they were harassed after and things like that. And I don't agree with that. He was deserving of representation, just like everybody else who was on whatever end of, any type of accusations. But I'll get off that for a moment. So then Senator Leahy, Democrat of Vermont, he goes on and he says that out of 115 justices in United States history, there's never been an African-American female on the court. I'm pretty sure there has been an attempt to nominate an African-American female, and I want to say that was by President George Bush II. I'm sure someone will fact check me, but she didn't make it to the confirmation process. Someone mentions that later on, and maybe I took a note on it. But moving forward, so Leahy also talks about that Judge Katanji Brown Jackson, she comes from a family that has law enforcement officers. And so that may have contributed to her endorsement by the National Fraternal Order of the Police. I just want to point out that if you were watching it, they kept, the camera kept like doing a, what's it called? Panoramic view when Leahy was talking, and you just see Dick Durbin just gazing at him. I don't know. I thought it was cute. It was kind of funny, but he was the only one doing it. Everybody else was looking down at their notes, and maybe they should have been paying attention too. But I just need to point that out. You guys will have to go back and look at it. Then Senator Graham, Republican, South Carolina, former chair of the Senate Judiciary. You'll remember that Graham presided over Amy Coney Barrett's confirmation hearing. So he talks about, you know, operating in the confines of the Constitution. And then, okay, so Graham brings up the Bush filibuster judge. And he says he just wants to point out that there have been attempts to diversify the Supreme Court in terms of making the court look demographically like America. But when it was Black and brown conservative justices who were put before, you know, they weren't given the same, oh my God, it's historic, oh my God, it's this, oh my God, it's that. And, you know, I don't think he was wrong for pointing that out. I do think, and both sides are guilty of this, but I do think particularly when it concerns Black and brown conservatives who may have conservative policy views and therefore align themselves more with the conservative party, they don't get the same consideration. You know, people can say that he shouldn't have pointed that out in this moment. Hey, it's opening statement days. I just don't think he was wrong for pointing that out. And to that point, and this, I don't know, this might be a little bit of a reach, but if you have morals that are roots, like tree roots, instead of morals that are leaves and branches, then you wouldn't have these flip-floppy problems and things like this. If you have morals and they are rooted in who you are, for the most part, it, to a certain extent, it wouldn't matter if it's a Democrat or a Republican or this or that. Those are your morals. And things that align with your morals, that's what you're going to stick with. And you're not just going to change and say, oh, well, the other side does it, so we should do it too. Or you're not going to say, you know, just do the opposite of what the other side does just because it's the other side. No. If you have a sense of morality or a sense of, you know, things that are somewhat immovable in your fiber as a person, you're going to stick with it no matter what side it is. And that becomes the problem. Anyways, Graham continues to talk about, oh, then he goes on this tirade about the people that Biden didn't pick. I want to say her name was Childs, Judge Childs from South Carolina. And I understand that, you know, he wants to see a fellow South Carolinian, but then he says, oh, she wasn't backed by this and that and yada. The fact of the matter is the president picks who he wants to pick. Point blank, period. And your guys' job as the Senate, you know, is to give advice and consent. The president makes the pick. I'm sorry that your pick didn't get it, but you're not the president. Run for president and win. And then when the opportunity arises, then you can make the pick that you want to make. And I will say something. You know, well, can we talk? I'm glad that for the first African-American woman, that somebody who had similar educational background to the majority of the justices got picked. And why do I say that? Well, I say that because I do understand we want to get away from thinking that the only qualified people are Harvard, Yale, you know, Ivy League, things like that. I understand that bright, intelligent people come from state school. I think I went to state school, maybe. I don't know. I didn't go to Harvard, is basically what I'm trying to say. And I'm sure I'm just as gifted as somebody who went to Harvard. But that's neither here nor there. But it is something to be said. I think that she compares with everybody else. You know, so they can't say, well, you know, she's less than in any way. No, she's right up there with all the rest of them as far as educational wise. I just think that was a strategic move. And hey, I actually particularly like Senator Graham. And so, you know, I get it. He wanted to go for the South Carolina girl, but you're not president. You don't get to pick. That's just it. He had a lot to say. He talked about the issue with her and the Gitmo detainees, and he actually said he commends her for defending Gitmo detainees. Senator Graham is an attorney, I believe. I want to say he was the JAG officer, but I'll have to fact check that and clean it up if that's not completely true. And so he understands that everybody is deserving and entitled under the United States system to representation. His issue was that she wrote amici briefs. Amici briefs are, you might not be a part of the lawsuit, but you might have an interest in it. So maybe you submit a brief to the court, just explaining your position outside of the parties who are actually party to the lawsuit is the best way I can explain it. But he said that she wrote amici briefs after she was no longer defending these people. And I think that's fair to ask her about, because that means that this was something that this was a position you took on without regard to your client. So I think that was a fair question. Again, he brings up judicial philosophy. I'll get into that. I'll try to find a place to work that in. He talked about the Kavanaugh hearings and talked about, holding salacious information until the last minute. I'm not going to lie. I did think that was ridiculous. If you had the information at the beginning, then that's when you should have notified people of the information. It did look a little suspect. You had information, and then at the 11th hour, you want to bring something forward. I thought that was fair. You can argue that maybe he shouldn't have brought that up, but whatever. That was ignorant, but hey, we move on, and we keep calm and carry on, my wayward son. So what else did he have? Okay, I talked about that. I talked about, he really did kind of go on and on about Judge Childs. And he basically said that, I think I wrote down get over it, but he basically kept saying that Katanji Brown Jackson, whether she knows it or not, is backed by all these groups, and there was a concerted effort to have her over Judge Childs and this and that and the third. And, I just don't like this acting like both parties don't have, what do you call it, dark money, deep money, interest groups, et cetera, that back their interests. Both parties have people that back them. Point blank, period. Amy Coney Barrett, when Trump was the president, he gets to make the pick. That's the pick he made. Let's not act like there weren't all these religious groups who want most people to live like them, whether they want to or not, that were backing her. Do I think that that's a problem? Okay, yes. But do I think that both sides do it and that's somewhat become the name of the game? Yeah. So if you're going to condemn it on one side, condemn it on your side too. Everybody's backed by somebody, and not for the good of the American people. But, I'm not going to go all into that. Let's see. So I think I got off of him because I will say that his Senator Graham's hair was looking very nice and polished. Move on. Dianne Feinstein, Democrat, California. She said that this is her 10th hearing or 10th confirmation hearing for a Supreme Court justice, which I thought was kind of cool. How it goes, and I'm not going to go through maybe everybody, or maybe I might, but the Republicans are going to highlight the past. They're going to talk about, what they're not going to do and that had been done to their picks before, because I think the last picks have been Gorsuch, Kavanaugh, and Amy Coney Barrett. So they've all been conservative picks. So and there were some antics. We're not going to act like there weren't antics. There were. So all the Republicans are pretty much going to talk about, we're not going to act like that. And they're going to talk about judicial philosophy and the things that they're looking for and their concerns. And then mostly the Democrats are going to talk about the historic moment and what this means to them. And they're going to go over her history. So that's what Dianne Feinstein did. She pointed out that Katanji Brown Jackson, KBJ, I hope I'm getting her name right and I'm not, mixing up anything. She was confirmed by this Senate, this exact same Senate, in 2021, so last year. And another Republican will bring up, so they're going to say, so what? That was then, this is now. That was for this is for this, which that's fair. And she'll be the first federal public defender on the court, which is cool. Then let's see, Senator Corrin, Republican from Texas. The reason that I give you guys the senators is because there's only 50 of them. And I think that it's worthwhile to kind of try to put a name, a face, and a state to these senators. Because sometimes you'll live in a state and you'll hear your senator talking and you'll wonder, who are they representing? I don't know anybody in my state who thinks like this. And they had to represent somebody in your state because they got voted. But a lot of times it's so far removed from us in our day-to-day lives that we just kind of gloss by them. The senator from this, and we gloss by their names. And not all senators spend all the time on Fox News, CNN, MSNBC. Not all senators do that. So I try to highlight them. And these are the ones in particular that are on the judiciary. So this isn't all of them, but anyways, Corrin, Republican from Texas, he says that this is his 8th set of Supreme Court confirmation hearings. I think that's cool. He talks about, the preserving the right to bear arms, preserving the right to practice your faith, discusses checks and balances. He goes into Federalist 7, 8. I just want to point out that the Federalist Papers, whatever they're called, that is not law. So we can maybe say that's legislative intent. In my opinion, that is just what it is, opinion. But those are not laws. And if you're not a conservative, then maybe you don't necessarily co-sign to the Federalist interpretation of things from the Federalist paper, not necessarily the Federalist Society, even though, it might kind of match up. But you might not necessarily agree. It is okay to disagree with a founding father. It is okay to have a difference of opinion. We are not put in this world to be mirror images of each other. How society has to operate is we all have varying interpretations of things and, opinions and things that we might have did different. You don't have to agree with everything that the founding fathers did to be an American. You can look at the founding fathers and, oddly enough, we have transcripts of the debate that went on when they were writing the Constitution at the Philadelphia Convention. We have transcripts of that. You can go through and read the transcripts when they're talking about, should we allow slavery or should we not allow slavery in this new Constitution that we're about to create. You do not have to agree with all they said at the time to be an American. You can disagree. Now, that's what won out. We have our Constitution. We all live under it. But the fact of the matter is that we all have just different perspectives and opinions, and I don't think that's wrong. So what else does he talk about? He said that Katanji Brown Jackson hadn't provided enough clarity for him. I don't know. The next day they'll get to ask their questions. He can get all the clarity that he needs to get from her. And I just want to point out too that when Amy Coney Barrett gave her hearing, she repeatedly mentioned that, you know, she's not gonna give forecasts. I think they call it the Ginsburg rule. She's not gonna give forecasts. She's not gonna predict upcoming legal decisions. And when they asked her about things that she may have written, I think she wrote a lot about abortion and the Affordable Care Act and severability and stuff like that. She pointed out, and the Republicans pointed out, and I think rightfully so, that those are things that was before she was a judge. Those are her personal opinions. And then when she became a judge, no matter what her personal opinions are, she is an ethical judge. And so she sat back and heard whatever the case before her was about. And I think that was fair. Now, you don't know how this person is going to act as a judge or as a Supreme Court justice. So all you can do is ask them about their opinions and about their prior, you know, literature that they may have written as private citizens and things. I understand that. But just like the Republicans kept saying for Amy Coney Barrett, that this is her as a private person. This is her before she became a judge. This is not how she governs her judicial decisions. I just want Judge Katanji Brown Jackson to get that same courtesy and that same level of understanding. But me personally, I do think it's fair game to ask about those things. And you know, Amy Coney Barrett, she didn't comment too much on it, and I didn't fault her for that. And if Katanji Brown Jackson doesn't comment, I won't fault her for that. But I do think it's fair to ask that, because we don't know how you're going to behave as a judge or as a justice. So all we can do is ask about what you wrote before you were a judge or a justice. So I just want to point that out because it comes up. It keeps coming up. So then Senator Whitehouse, Democrat from Rhode Island, speaks, talks about civil litigation experience and being a public defender. And also pretty in a point blank way called out the Republicans and said that we all have donors and things like this, and dark money goes into all of the justices. And so that's my point from earlier. Then we have Senator Lee from Utah. Senator Lee was the first one to mention her family, and, you know, you have a lovely family. I was glad to meet you. And I thought that was very polite. I like to see, you know, everything can't be fake pleasantries. However, there is something to be said about being civil, and that might be speaking as an attorney who takes an oath of civility. It doesn't take much to be nice, but I just thought that was nice. Senator Lee says that she has a unique set of experiences and a unique perspective, and she served at all 3 levels of judiciary. He says that out of respect to human beings, he hopes there's no personal attacks, you know, bringing back up what happened in the past. And he wants to talk about judicial philosophy. He talks about, Senator Lee says one of the things that he's interested in is judicial restraint, and this idea of not legislating from the bench. He goes into, you know, separation of powers, interpret the law as written, and mentions court packing. So I will say this. This idea of originalism and textualism, first off, if you're a conservative and that's how you do judicial and legislative interpretation as an attorney or as a judge, that's fine. Not everybody is you. Not everybody's like you. I personally, and I tend to lean conservative in my judicial interpretations of the Constitution. I don't know if I'll go as far as to say the Constitution is a living, breathing document. I don't know. But what I will say is this: when you go to court, the problem is that there's an ambiguity somewhere. We are in court because something needs to be interpreted by a third party. This attorney has interpreted it one way. This attorney interprets it another way. This court said it one way. This court said it another way. And now we're at the Supreme Court to make the final interpretation, because words put in text, put in sentences, may have different interpretations. We all speak the same English language in theory, when we're in court is what I mean. But the reason we're in court is because something needs to be interpreted because it wasn't plain. So this idea of saying stick to the plain meaning of the text, how can you stick to the plain meaning of the text when the whole reason that we are in court is because we have two different interpretations of the plain meaning of text? So are you saying that stick to what I interpret the plain meaning of the text to be? You can't be, because you're not the only person in society. Originalism says, and I think it might be Lee who kind of broke it down, but somebody broke it down, basically says how the framers would have interpreted the Constitution at the time, they wrote it. I just think I don't understand that, because our world is not how the framers would have saw it. For example, if we're discussing something like the internet, the framers wouldn't know what to do with that. Now, would they know what to do with free speech? Let me put a pin in that. Would the framers have the ideas of the liberties that we're trying to achieve, even though we're talking about something that they would not have known about? Sure. But we have to realize that the framers knew that the world wasn't going to stop in a couple of years. You're telling me Benjamin Franklin, who was at the Philadelphia Convention, who was an inventor, he thought the world was just going to stop, that we weren't going to have new inventions, that we weren't going to be a society that changes over time? To me personally, I think that the better application is to look at legislative intent, particularly when we're talking about the Constitution. We have transcripts, lots of transcripts, where the framers are in debate and breakout sessions talking about why we want this language in here and why we don't want this language in here. To me, the legislative intent gives a better understanding of the spirit of what the framers intended. When we say spirit of the law, what attorneys say when they're talking about a spirit of the law is that the law says something, and maybe in its application, it's not really doing what was intended, because the spirit of the law is to do this, but as read, it's not really doing that. So I think that looking at the legislative insights and intent is a better way to go. So why did I put a pin when we're talking about the First Amendment? If we're talking about the original text of the Constitution, if we're talking about what came out of the Philadelphia Convention, the First Amendment didn't come out of that. It's called an amendment for a reason. It was added on after the fact. So if you are truly an originalist, then you can take out that First Amendment and the second and the third and so on. They did discuss, I think at the end, towards the last days of ratification, they did the idea of adding First Amendment protections and things like that. Most of the states at that time had their own, I don't know if they called them Bill of Rights, but they had their own First Amendment protections and right to bear arms and yada, yada, yada. But no, it didn't make it into the original Constitution. That's why it's called the First Amendment. Amendment, by definition, means that something was added on. So the framers put in a system to amend the document because they knew that time would change. our wants and needs in society would change. It's how we freed slaves. It's how we made them whole persons in the eyes of the law. It's how the right to vote for African Americans and women, and et cetera, et cetera. There was a system in place to amend the original text of the Constitution. Our framers didn't want you to be able to amend it every day. So they made it a hard process. They made it a slow process. But to me, my opinion, by the simple fact that the framers were able to put a process in place for amendments, to me means, yeah, they knew it just wouldn't stay the same. But, you know, this originalist and textualism, if that's how you interpret the Constitution, that's fine. But I just don't think that's the only way to interpret the Constitution. And nor do I think that the whole court needs to be a court full of, you know, textualists and originalists. I want there to be debate, all sides, everybody. If we're making the court look like society, it's also going to think like American society. We're very diverse in America. We are fortunate to live in a country where we're supposed to be able to have all different types of ideas, and they come together, and then we make a better idea. So, you know, harping on the fact that she's not an originalist or textualist, which I don't know what she is, because she hasn't even got to say what she is yet, but we'll hear about that later. So I'm done with him. Klobuchar, Democrat from Minnesota. She talks about Katanji Brown Jackson's parents, and she talks about how Supreme Court decisions affect real people, healthcare, DACA for the Dreamers, voting rights. She talks about Ukraine. You know, the Democrats they don't have much to attack on, so they're just kind of, hey, look, our picks here. It's just opening day. Everybody chill out. So that was fine. Then Senator Cruz, Republican from Texas, talks. I'm not gonna lie, I don't mind Ted Cruz to an extent, but I just feel like his voice is always louder than everybody in the room, and it comes off as screaming. And I try not to get too irritated by it because, you know, as people, you know, we have different personalities. Some people get a little bit more animated when they talk, but I bet that if we put a decibel meter, I think that's what it's called, to measure the volume in the room, it just seems like he talks so much louder than everybody, like he's screaming. And a pet peeve of mine is, if we're having a conversation, why are you screaming? But, you know, I'm going to try to get out of that. You know, I think, and Ted Cruz did mention it, another Republican mentioned it earlier, about how Republicans always get attacked and called racist whenever they don't like a black or brown candidate, or, you know, they always get called racist no matter what they do, is basically what the gist of it. But Ted Cruz made a comment, and he said, well, the Supreme Court changed when they became policy makers in the 60s and 70s. Yo, that's the civil rights era. You know, women, black folks, LGBTQ to an extent. And it just, you know, it's just real tone deaf. So that's the era that you decided to point out, where the Supreme Court, they were making policy decisions and not legislative decisions. Yeah, they were making decisions so people like me could. I'm not going to stay on him. I really can't do him. I just want to know what happened to Ted Cruz. He didn't used to yell like that, or maybe I just didn't pay attention that much. I do feel like he screams all the time. I'm going to move on. Senator Coons, Democrat from Delaware, he goes on about Katanji Brown Jackson's resume. And then he makes a point to mention that most Supreme Court decisions are unanimous, but those aren't the ones that make, you know, news. Those aren't the exciting ones. I've heard that before, and I actually believe that. Ben Sass, Republican from Nebraska, talks. Ben Sass don't hold his tongue. He basically said that all branches of government were reckless. He said the reason that that they're legislating from the bench is because it's dysfunction in all three branches, all of them. I had to agree. He mentions Burke from the 80s, a confirmation hearing that went left, I guess. Left as in wrong. Kavanaugh, Amy Coney Barrett. And then I just have to say something about C-SPAN. So this was at like 1 p.m. C-SPAN gonna put at the bottom of the screen, we're gonna cut away to go look at the House briefly. Excuse me? Whether anyone likes it or not, this is a historic hearing, and y'all are gonna cut away to the House of Representatives for a non-voting action. And then when they did cut away, we stared at the door for 5 minutes. What? And then they had the nerve to say, oh, you can continue coverage of the confirmation hearing on cspan.org. No, you should have kept it on the confirmation hearing, and then you could have went to cspan.org to see the non-vote in the House. But I'm giving the side eye to C-SPAN right now, because I really did feel like it was something about that I didn't like. Okay, so what else did I have? Sass says he wants to focus on how the judge reasons and works out her decision. He says he doesn't mind what decision they make, as long as you don't have to agree with someone's judicial philosophy to understand that they're coming from a place of logic. I feel like that's what he was trying to point out, and I agree. Even I just said that I'm not really an originalist or a textualist, but I understand when I read or hear the judicial philosophy of someone who started from a place of logic, and they just work through whatever steps through originalism and textualism, they work through it. That doesn't mean we're going to get to the same conclusion. It just doesn't. It doesn't. People can have the same set of facts and come to different conclusions. Sometimes, but perspective, it happens. And he was cool. And then we have Senator Blumenthal, Democrat from Connecticut, I think. He talks about I don't know what he was talking about. He basically just used this time to say the Republicans talking a whole bunch of stuff, but he didn't have too much to say. Then we have Hawley, Senator Hawley, from Republican from Missouri. I've heard it both ways. I'm wondering if that's one of those things where if you're from Missouri, you say it one way, or if you're not, you say it another way, but it doesn't matter. His concern, and to his credit, Josh Hawley said he mentioned this before the hearing because he didn't want it to be some last minute thing, bringing up something to act a fool. He wanted to be open and honest about this. I don't give Josh Hawley much. I do think sometimes he can be an agent of chaos, but in this moment, I think he was fair. So Josh Hawley's concern was that, particularly when it came to cases involving child images that are not what they need to be, y'all gonna have to read between the lines. I'm new to YouTube. I know they got rules. I really don't want to mess anything up. But the point is, basically, she always gave she gave low sentences for these cases. And he points out 7 cases where she had discretion. Some cases, as a judge, you don't always have discretion, or you don't always have an option of what sentence you can and cannot pick. But in these particular 7 cases, he points out that she did have the option to define the sentence. and she gave lower sentences. I think she gave sentences that were less than the federal sentencing guidelines. And he said that just concerned him, and he wants to know what was her motivation behind that. I think that's fair. I think that's fair. As a judge, what motivated you to seek lesser sentences in these cases? And is that part of a wider philosophy, or is that indicative of a wider philosophy that you feel like the sentences, you know, I can't say that wasn't fair. I can't. However, when it comes to sentencing people heavily and not giving light sentences, I just want us to have that same energy for everybody. That's all. If we're going to be giving leniency on people, that's fine. I just want us to do it across the board. I want to have that same energy for everybody. And if we're going to be giving harsh sentences for people, I still want that same energy for everybody. But you know what? Me and Josh Hawley, you know, we on good terms right now. So, and I personally, I appreciate the fact that he said, yeah, I raised these concerns ahead of the hearing because I didn't want to bring up some mess, you know, at the 11th hour. I respect that. Senator Hirono, Democrat from Hawaii, she basically just went down the resume, and she said, you know, it's about time. I want to say she was right before the break. She didn't speak long. For the opening, most of the time it's going to be, if it's a Democratic pick, then the Democrats aren't going to, you know, get into much, but the Republicans are going to have a lot to say. And if it's a Republican pick, vice versa. That's just how it goes. So I want to say when we come back from the break, Senator Cotton, Republican from Arkansas, or what's the thing, Arkansas? Anyway, Senator Cotton speaks, and he says that Biden is waging war on justice, and there's a breakdown in society. Parents are scared. He talks about the 2020 riots, the 2020 left-wing riots. So I guess the riots, George Floyd, Breonna Taylor, the riots that were prompted by those incidents. I just don't like, again, I just don't like this idea that it's one or the other. Both sides do this. Like, the world is not ending just because there's disagreements on how we govern society. As Americans, that's how our society operates. And we say that that's what makes us the country on the hill. So whatever, but hey, I'm sure that it's going to come up in a political ad or something. Cotton also talks about, he says it's not enough to say you're going to look at the law, you're going to look at the case before you and interpret it fairly. And that's what Amy Coney Barrett said. And I agreed with her when she said that. Yeah, I don't know what case is going to come before me, but as a judge or as a justice, I'm not representing these people. My job is to look at the facts before me and evaluate the case. And I think Cotton was an attorney or legally trained, but that's what you do. That's what you do. Your job title is not private citizen anymore. Your job title is not public defender anymore. If your job title becomes judge, or if your job title becomes justice, then yes, you now have to employ a different skill set than you maybe did before. You now have to wipe the slate clean. And when the case comes before you, and then when the case comes before you, you need to evaluate the case in that moment. Now, as people, do we all bring a little hot sauce to the table? Yeah. As conservatives, Democrats, whatever. Yes, we all bring perspective. We all bring experiences that might point us towards one way or the other. We all bring different things that allow us to look at the law and maybe see something a little bit different. But the whole point is that's why there's 9 of them. There's 9 of them so they can hammer that out and get to a decision that they can make for us. Y'all, there's a moving truck outside. Oh, thank God. You know, look, I do this outside of my house. Y'all are just gonna have to bear with me. But anyways, I just I just be consistent, be a root in how you think. If it was fine for Amy Coney Barrett to say, you know, that was me before in my new job, I'm just gonna have to wipe the slate clean and look at the facts of the case and, you know, judge fairly based on X, Y, and Z. If that was fine for her to say, then that should be fine for this one to say. But that's the difference between your morals being roots and your morals being leaves. But I'm gonna get off that. Then we had Cory Booker, Democrat from New Jersey, talked, and all he did was gush, gush, gush. Oh my God, it's historic. Oh, I'm just so happy to see you. Oh, it's wonderful. I mean, there's nothing wrong with that, but I mean, that's the only note I had. I'm sure that he will have more to say during the questioning part. So tomorrow and the next day. But whatever. So then we have Senator Kennedy, Republican from Louisiana. Y'all, when he got to talk, I almost left. I wrote, "Here we go." I thought he was gonna act a fool. I just knew that he was gonna. Am I a racist? Am I a racist? I forget where he was when he did that, but you know, but Senator Kennedy was fair. He said he wanted to compliment the Biden White House for choosing Doug Jones as Katanji Brown Jackson's advisor. He said that Doug Jones was a person of good judgment and goodwill. I said, okay, that meant something. Again, I like to see the civility. I like to see. I don't mind. I don't. It doesn't have to be fake, but I do like to see a little bit of, you know, old school politeness. It's okay to compliment your adversary politically. If it's your political adversary, it's okay to give a little, take a little. I like to see it. But Senator Kennedy said he was concerned primarily with two things. The first thing was the legitimacy of the court. And he talks about, you know, where did the court get legitimacy? What can the judiciary do to enhance it? The role of the court, upholding the rule of law, even when it's not popular. He talks about the Bill of Rights. I just want to point out that those are amendments, but whatever. He talks about the impeachment of Earl Warren. I think this is before my time, and I'll just have to do my research. But I know there's a lot of criticism about, oh, some of these people are too old to be serving. I like that there's a mix of ages, because I do think that some of these stories that the older senators witnessed, I think that's something to be said when they bring up some of those stories. And I think that the younger, if they let them get in, some of the younger senators also bring a set of experience. And I think that mixture is good, which is why I personally like how our Supreme Court is set up, because I like the fact that you have different eras, different time periods of representation on the Supreme Court. So to some extent, no matter if they're conservative or not, conservative or liberal, I guess is what we call them, those time periods in their thinking makes a difference. And I like that, you know, as the Supreme Court justices make their way off of the court, different time periods come on in a very slow moving pace. And I think it's what the framers built in as one of the mechanisms to keep us from having a regime change, you know, every couple of years. I think at the time when our country was founded, they were looking at Europe was having revolutions every night. They wanted us to have a system for changing, correcting, altering whatever we needed to in government, but they didn't want us falling into chaos just because there was a change. So anyways, okay, so the first thing Senator Kennedy says that he wanted to talk about was the legitimacy of the court. And the second thing was appropriate balance between representation and declarative government. He said representation government is what, you elect somebody to represent whatever it is you elected them for. And he said declarative government was administrative agencies, and how he said he didn't like the fact that you can have 35 administrative laws before Congress passes one law. And I understand where he's coming from. I do. But my thing is, that's y'all's fault, Congress. And I'm going to do a separate video about that. Congress, that's your fault. Fix it. And then Congress can make a law. And if Congress makes a law that is counter to the administrative law, Congress trumps. Congress has supremacy over that administrative law. Congress makes the laws. The executive branch, which is what the administrative agencies operate out of, they execute those laws. So my thing is, if you don't like a decision that an administrative agency or an administrative rule, then make a law that say you don't like it, but y'all don't know how to work together. So now you're mad because you can't get anything done. That's not the administrative agency's fault. Another thing I will say about administrative agencies, you can still challenge an administrative decision. If there's an administrative decision, it can still be challenged, and by the appellate power of the court can make it out of administrative court into the Supreme Court or to the Court of Appeals, XYZ, wherever it has to make it. So the whole of government is a check and balance. There is not one part of government that cannot check and balance another part of government. But I did understand what he was saying, but my thing is, sis, that's not their fault. Y'all need to get in there and make laws. He talks about judicial restraint. It was okay. I'll be interested to see his questions tomorrow. Senator Padilla, Democrat from California, he speaks. He said, and this actually goes to a point that I've been talking about. He says the men that wrote the founding document, they would have never imagined that Katanji Brown Jackson would be sitting in front of them, or that some of those senators would be. They wouldn't have even imagined a society where she was considered a person. And when we say things like that, that's not saying we always need to topple the norms of American society. But what that is saying is that just consider the fact that society has changed, and how we think of people and the things that different groups of people should be capable of maybe do change, and maybe rightfully so. Does that make us non-American? No. Does that mean we want to throw away all of our ideas? No, but just something to consider. Then he spoke a few words in Spanish. It sounded like a paragraph. I'm gonna leave it alone and move on. Senator Tillis, Republican from North Carolina. I'm not gonna lie. Senator Tillis, let me move on. I'm just gonna say it. Senator Tillis, I think overall that, a lot of times he makes sense. But one thing he did in 2021 that I did not like, his Democratic opponent, he said something, and he's just a trial attorney. That man was in the military before he was so-called, quote unquote, just a trial attorney. I did not like that. I also don't like this idea of picking on trial attorneys. Yeah, I might be personal because I am an attorney, but the point of the matter, why are we picking on people who have jobs that can pay their bills? When something happens and you need a trial attorney, you're going to call one. Donald Trump needed a trial attorney when it came to that impeachment. I just didn't like that. And ever since then, especially someone who was in the military, he was in the military, and I'm sure his military service probably helped him become a trial attorney. Either we're for the troops or we're not. I didn't like that, but he talked a good game. He said that, he talks about judicial philosophy, originalism, and textualism. And again, I understand that's important to you, bro, but not everybody thinks like that. And you have to realize your way is not the only way. I wish my way was the only way too. Actually, no, I don't, because I do think it makes me a better person whenever I can get a little bit more information input. That's a different conversation for a different day. I moved on from him. Senator Ossoff, Democrat from Georgia, spoke, and I didn't take many notes on him, but he did talk about Ahmaud Arbery and the importance of representation in the court system. Yeah. I'm sorry. I wish that as a whole, more people had the ability to empathize with a different person, or someone who looks different, thinks different, acts different, walks different, talks different. But not everybody has that. And that might not be their fault. It might not be purposeful that you don't see things differently. You might only be able to put things in your purview, in your life experience. That's okay. But then don't get in the way of people who have different experiences, who can bring something to the table, who can maybe help more people. The American melting pot. But I didn't take many notes on him. Then you have Blackburn, Republican from Tennessee. I think I got that right. She talks about, splaining. It's not mansplaining. I don't know what kind of splaining she was doing. We do have the role of advice and consent. Duh. I'm sure Katanji Brown Jackson knows that. Maybe she was saying it for the audience at home, but I think they know it by now too. She talks about parental rights getting taken away. She talks about a progressive agenda, trans athletes, teaching about is it her that mentioned CTR? Yeah, she mentioned CTR, leniency on crime. She had a lot of she talked about a lot. She talked about a lot that she was concerned with, but the overall gist that I got from her is her problem was she didn't want a liberal judge. I don't know what to say to that, because elections have consequences. We've heard it several times. You're not the president. If you become president, then you're going to pick somebody that probably aligns to maybe your idea of it. The fact of the matter is the president gets to pick. I don't have to like it. I don't know if I'm going to agree with a lot of things that she says, but the president gets to make the pick. So it is what it is. I don't know. She talks about the get more representation too. I just don't understand what y'all think it is. When somebody in this country goes into our court system, they have to play by our rules. That's not my fault. That's not anyone's fault. You come to our court, then you play by our court rules. You don't go into American court and they say, oh, well, this person is this, so they're not entitled. No. Everybody's entitled to counsel. And you have I just don't. You do not, as an attorney, you don't co-sign to your client necessarily. That's all I will say about that. Anyways, I didn't give her much. That was the end. That was the end. And then the two introductory witnesses spoke. Retired United States Court of Appeals judge for the DC Circuit Court, Judge Thomas Griffith, spoke. He was a Republican nominee. And then Lisa Fairfield, somebody fact check me in the comments. She spoke. I think she said she went to school with Judge Katanji Brown Jackson. And then Judge Katanji gave her opening remarks. And of course, she gave a shout out to her family. She said that her name is Katanji Anika, a name of African origins. and it means lovely one. I thought that was sweet. Talks about her husband, her two little girls. They're big girls, but they're little girls. I'm sure they're always going to be their parents' little girls. Um, and that was the end of day one. So this turned out a little bit longer than I was trying to. I'm sure I went on a soapbox, but I'm gonna get better at staying on point. I'm gonna try to come back to you guys with a recap and review for day 2 and 3. I'm not making any promises. I might put the recaps on the NRE blog website. I might put this on NRE blog too, just for those who'd rather read it. That's NRE blog, INREVLAWG.com. But thanks, everybody. I hope this encouraged you guys to follow the confirmation hearing. Okay, bye.